answer on the Public Works and Safety Service Director why he hasn't. Morning. It is Tuesday, February 8th. The Richland County Board of Commissioners are now in session. I'm Commissioner Tony Vero, joined with Commissioner Cliff Mears, rocking a very cool vest and tie today, looking very stylish in Cameron land. Daryl Banks also rocking a vest. I guess I missed a memo. We have our clerk, Stacy Crawl. Doesn't have a vest. The nation's former leading scorer at the University of Akron, Joe Jakubik. Former Madison trustee, Miles Hain. County Administrator, Andrew Keller, and our Wayne and Garth online today.
Alan Carl are online.
So we do have Al Lawrence and Carl Hunnell. So we'll get started here. But before we do, I figured we'd open it up to our guests in case you don't want to stay for the exciting parts of the meeting. So, Mr. Jakubik, do you have anything for the people of Richland County?
No, I did work with Charles Minnick. There's some lights that at a couple of different county properties that they leased from Ohio Edison that weren't functioning properly. So working with him, we got those all resolved. And that's really about it at this time.
So not a lot of power outages in the big storm?
No, we were really, really blessed. There was just like onesies and twosies, nothing significant. You know, obviously when the prediction of what we were going to get hit with, there was a lot of concerns.
Yeah, we avoided the heavy ice, which was
Right.
we didn't get an easy storm, but we avoided the nastiness. So.
Yeah, ice and wind is always a huge red flag for us, but we were fortunate at least for this storm.
Well, we always appreciate Coach and First Energy for making themselves available to help out in a pinch. Even if he shoots left-handed, we still appreciate his altruism. So, Mr. Trustee,
I get a little nervous when I have to talk publicly.
you were a trustee.
So bear with me a little bit. The public hearing for the vacation of Green Acres Drive. I'm questioning whether that's required or even necessary. And the reason I question that is because 5553.04 is where it gets into the meat of doing that kind of thing. And it talks about the county commissioners can locate, establish, alter, widen, straighten, vacate, or change the direction of a public road. Obviously, vacate is in there. It also goes on to say that if you get a request to change, to locate, establish, alter, widen, straighten, vacate, or change the direction of a public road, you shall follow the directions in sections 5553.04 to 5553.16. The thing that requires a public hearing is in 5553.05, so it's within that range. But again, this talks about a public road. That's all it's referring to. In 5553.05, it says if you're going to do any of those actions subject to 5553.04. So it refers back to 04, which again refers to public roads. My contention is that Green Acre Drive is not a public road. The reason I say that is because the definition of a public road is a road that is open to the public for public use. Green Acre Drive has never been opened, so it's not a public road. Furthermore, if you go into 5553.23, it even goes in to say that commissioners, if you're vacating a road or a public road is open, maintained, and improved, that's part of what a public road is. This road has never been opened, it's never been maintained, and it's never been improved for over half a century. So I question, and now I'm not a lawyer, so this is just a question, but I question whether or not that section of the law applies to it. Throughout this whole section 5553, the law is very clear to distinguishing between public road and just a road. Okay, so there is a difference there. When you get to 5553.10, the whole beginning of it talks about the proceeding for the location or establishment of a road, board shall open the road. Again, you're back to open the road. And established, and such road shall be a public road when it's opened. But when you get down to the end of that section 10, there's some significant differences. The last paragraph, which is one sentence long, says a road or part thereof which remains unopened for 7 years after the order establishing it was made or authority granted for opening it shall be vacated, and the right to build it pursuant to the establishment of the original proceedings therefore shall be barred. The last part of that says the right to build it. That implies that you have to actually have a physical road before it can be a public road, not just a paper road. What we have with Green Acres Drive is a road that only exists on paper. If you look at, and I'm sure you guys have seen the pictures of it, there has never been any type of road of any kind there, so it couldn't have been open to the public.
So what is your ultimate contention, regardless of the legalities of the side? What is your belief, the legal standing of whether this is a road or not should be?
Well, I believe it should not be a road, and this, I guess, if I can go on to this last part again, there's some significant differences.
Okay.
Right off the bat, the word public is omitted. It says a road. It doesn't say a public road. So there's another place where lawmakers distinguish between the two. It says it remains unopened for 7 years. Again, a public road is one that's been opened to the public. This has remained unopened. Key word, and this held up the trustees for about 7 months because they had some trouble understanding the difference between shall and may. It says it doesn't use the word may anymore. It uses the word shall. That's a significant difference. Pull this up real quick. The legal meaning of the word shall is that it is imperative and mandate. In contrast, may means basically you have options. And it even, like I said, it listed 7 options, and there's actually an 8th that's not listed, but it's implied by the word may. It says you can do those 7 things, but that also implies that you can choose not to do any of them. So you have 8 options. But when it uses the word shall, and they had to go to the prosecutor, Amanda did what any good lawyer would do when they said, if it says shall, do we have to do it? Or do we have the option to not do it? And she did what a good lawyer did and said, let me look into it. She looked into it, got back to him and said, shall means you must do it. Okay. They still had some problems with it. But like I say, after 7 months, we kind of got to the point that they said, okay, so we'll pass a resolution to vacate the road, but the county commissioners can do whatever they want. My response to that was there are no government bodies in the United States that can just do whatever they want. They all have to operate within the confines of the law. So, like I say, after a period of time, they finally got that. So it does say shall, and when it says shall, it eliminates 7 of those 8 items because it says it shall be vacated. It does not give commissioners or anybody else the option to do anything other than vacate. Doesn't say you can say, I'm not going to do it. And to reinforce that, it even goes on later to say that if you decide that you're not going to vote on it at all after 60 days from the time that you receive the resolution from the township, it will be deemed vacated. So basically it's saying, and I'm not talking about you guys specifically, but it's saying if commissioners do not take action to do what the law says, then the law will do it for you. So that basically is saying there is no option here. That takes us to the public meeting. The purpose of a public meeting or public hearing is so that you can hear the public so that they can try to sway you or influence you to pick whatever one of those 8 items you're entitled to do, whichever one they support. You know, they'll say, well, I want it altered. Somebody else said, I want it straightened, something like that. But in this case, there is only one option. So it doesn't matter what anybody from the public would say, it would not change the law. It would not change your options. So that, because of that, I question, is there even a reason to have a public meeting if the public has absolutely no say in the matter? Again, this is not a public road. All the things that say that you have to have a meeting, even in 53.23, which is outside that range, when it talks about things you do there, it goes in and details again what you have to do for a public meeting. But for this one, for a road that doesn't exist, it does not say that.
So just so I'm understanding you correctly, you're of the opinion that a hearing is not necessary because the law is clear as to what should happen.
That plus the fact that the law, I don't believe the law says that a hearing is required for a road that is not a public road. You have a public road, you have a public hearing. I don't think the law requires it. And I'm not expecting you guys to say, wow, you're right, we're gonna all vote today, you know, because that's unrealistic. But I'd like you to consider it. I'd like to know your thoughts on it as to what each of you think.
I'm just, again, and we'll look, I mean, the law is going to be the law and it's going to dictate the process. So that this is an easy one in the sense that we have a sharp legal mind behind you. And I know I can read a little bit of law. So I'll get with him and we'll review. I just want to make sure we can respond accordingly to what you're asking or what you're saying. So is it your opinion that ultimately the land is vacated by an operation of law? In other words,
Correct.
okay.
Like I say, it says that if somebody wants to build the road, and when it says right here, right to build it, implies that you have to do something. You have to actually physically have a road before you can say it's a public road. That the law is pretty clear, says there is only one option, and that is to vacate it.
Just out of curiosity, as a former trustee, and I think ultimately we'll get to vacating public hearing, non-public hearing. What is your concern with a public hearing? And doesn't the public get afforded an opportunity to, in the interest of transparency, what would be is it just, hey, the law says there shouldn't even be a public hearing, or?
I don't have a problem with a public hearing. I'm saying I don't think it's necessary. In the grand scheme of things, it's basically a waste of taxpayer money. It's a waste of your time and the public's time, because the public cannot say anything that would influence you to do anything other than what the law says.
Okay.
There's just so you know, there's some other people that are waiting to see how this plays out, because there's a number of roads in Madison Township that fall into the same category. And we're hopeful that things will go a lot smoother as we move forward once we get through it once.
I think, you know, between Andrew and he's got more than a little knowledge of the law. Between those two, we'll figure this out. Come back with.
Andrew, do you have any thoughts now, or do you need, I mean, we obviously don't need to offer legal opinions, but you have that. It's why we hired you amongst many other reasons.
Because it's set for hearing, obviously we can't comment on the underlying merits of the action. But as far as this concern about whether there should be a public hearing, well, the purpose of a public hearing is to provide due process. It's also to provide the opportunity to create a record, to establish the facts. I mean, you're indicating that, you know, this is created and or platted and or established as a road, paper road, over 50 years ago. Well, even that information would be presented at the hearing. So even in situations where the result could be mandatory by law, a hearing is still required to be had. And I know that might seem counterintuitive, but it's an opportunity for the public to be heard and for the commissioners to take into the record all of the facts that, you know, and like I say, under certain fact patterns that could create a mandatory, you know, decision that the commissioners have to make.
I know that it does talk about meetings for the plats and the engineers meeting and everything like that. But it also distinguishes that there's a hearing and then there's a meeting. And
By,
it says you have to have those meetings, but it,
by analogy in a judicial context, you know, there are, and this is a strained analogy for legal purposes, but still. If in a criminal action, if there's a mandatory penalty to be imposed at sentencing, you still hold a hearing. It's mandatory. The judge has no choice, but you still hold a hearing.
So if I'm hearing you, Andrew, and we can wrap this up, it's, hey, at the end of the day, the law is probably going to say it needs to be vacated. I think we're but the law says you still got to have a public hearing to create the record and to create the due process, right? Am I hearing you properly?
Yeah, I'm not saying that the law says it has to be the commissioners will make that decision, you know, based on the facts that are presented. But we do have to have a hearing. And I actually appreciate your close reading of that sequence of statutes because commissioners are in those statutes from time to time, and it can be a challenge sometimes applying those statutes to these aged plats that came into being in the 1950s.
I do disagree with one thing you said. You said that government bodies got to go by the law. Right now, we got a lot of government bodies in the United States that aren't going by the law.
I'm not,
Let Andrew and I talk about it a little more. And he knows infinitely more than I do, but
And
I'm in-
ultimately talk to the prosecutor, because the prosecutor, as Miles mentioned, has been involved in this and they'll be able to provide some insight as
she-
well.
we didn't go into anything about meeting with her. It was just, what does the word shall mean?
I still say, Mr. Hain, I guess, and we're not going to beat this to death. To me, transparency and public input is always a good thing where I sit. So even at the end of the day, if the result is dictated by law,
Sometimes it's good to give.
sometimes
people
it's
the
good to
thing.
give an opportunity to speak. So I don't see this as a bad thing per se. I mean,
But
we'll take a look at it from a legal perspective.
I appreciate that. And like I say, I'm not opposed to having the meeting. I do like to look at things though as what is the proper way to do it. And if it's not required and it's not necessary, you know, from a taxpayer standpoint, I do it. But you,
Okay, we'll take a look. Let me,
opinion on it.
before you leave your number with Stacy or Belinda. Do you have it, Stacy, by any chance?
I don't have his phone number. No.
Why don't we, here, let me, got a sticky note there. Why don't you write your number down and Andrew and I will take a look at it. We'll, I'll get with, F. Lee Bailey back there. Well,
He's not looking at you, Joe.
he knows better. He's more Judge Judy, isn't he? I think she's a lefty too, isn't she?
Probably.
All right, we'll take a look at it. We'll get back to you. Actually, I appreciate you reading the code. That shows some effort and I can't thank you enough. And I'll make sure to tell Dan Fletcher you're way smarter than he is when I see him next time. So,
Dan's going to be one that will come in and try to talk you into doing something different as well.
okay. Well, I love telling Fletcher to pound salt, so I look forward to that. So,
Thank you.
all right, take care, Mr. Hain. Okay, moving on. I actually have just a little bit of correction, Stacy, in the minutes. If you look at two, it says HR contract Kelly Christian. I think it should be Kelly Christensen. I'll ask that we I'll make an amendment.
To approve that without amendment.
There you go. I signed it anyway in case it doesn't change format.
Second.
Mr. Barrow,
Yes.
Commissioner Mears.
Yes.
Thanks.
Yes.
All right. Motion to approve requisitions.
So move.
Second.
Commissioner Barrow,
Yes.
Commissioner Mears.
Yes.
Thanks.
Yes.
All right, we got a couple add-ons. One is never good because it's going to cost additional monies. But if you recall, we had a water break.
It's not, that quote is for our parking lot.
Oh, I thought it was for,
This one right here.
That's the one behind, or,
And it's under what was projected.
oh my gosh, I stand corrected. Oh. Well, then we're supposed to make a motion to accept the estimate to do some parking lot work. There's a list here. If anyone in our media land has questions, we're removing some curb. We're pouring a new catch basin. We're placing limestone, grading the slope, et cetera, et cetera. Report repainting parking strips, providing traffic control. So we're doing a whole host of things for a total of 37,659.84. And I can't believe this, but Stacy's saying it's even cheaper than we thought.
Which is good because that will help pay for the concrete.
Yes, it
on the
will.
Water break.
It'll pay for the concrete and the water break. So motion to happily accept this estimate.
So move happily.
Second, and when they gonna do the work?
We don't know yet. We're getting on their list and then we will be notified how
When the
long.
weather breaks or
They're
whatever.
checking it twice.
Yes. Commissioner Vero,
Yes.
Commissioner Mears,
Yes.
Commissioner Banks.
Yeah.
Yes.
Okay, we also have another add-on. So our dog warden reached out to me yesterday. As you know, they've been operating behind. We had approved a part-time deputy out there. She has graciously asked that Mr. Endicott start February 10th instead of the 17th. He has gotten with the auditor's office, and Pat, being the kind soul that he is, said, sure, that'll be fine. We always like to start people at the start of pay periods. But she's asking that we move up his effective start date to the 10th. Pat says it's okay, so I'll ask for a motion that we do that.
So move.
Second.
Commissioner Vero,
Yes.
Commissioner Mears,
Yes.
Commissioner Banks.
Yes.
That'll be it from a logistical standpoint. We do have a 10:15, which is going to executive session to discuss discipline of a public employee. But are there any questions from media land?
We don't have any questions, Tony, but I want to point out that you compared Joe to Judge Judy. Joe's a lot better looking.
Thank
Let the record reflect there's vehement disagreement on that.
I'll second that.
He isn't as good looking, not as wealthy. Carl, Mr. Snowplow?
I got nothing. Got a border control meeting in 10 minutes, so I'm okay.
All right. Seeing no further business at this time, we will recess at 9:52.
Is that the number she's always supposed to call
For executive sessions,
for
yeah.
executive sessions? You are. Okay. Yeah.
Okay, it is 10:15. Your Richland County Board of Commissioners are now in session. This time I'll ask for motion to go into executive session to discuss the discipline of a public employee.
So moved.
Second.
Commissioner Barrow,
Yes.
Commissioner Mears.
Yes.
Commissioner Banks.
Yes.
Let's rock. Okay, we are back in session at 10:27. After discussion with our Day Spring management team and ourselves and Mr. Keller and our HR director. At this time, I'm going to ask for a motion. And that motion will be to impose a 1-day suspension of a Day Spring employee for a third group 1 offense, a 2-day suspension for a fourth group 1 offense, and then a 2-day suspension for a group 3 violation. So just so we're clear, that would be a total of 5 days of suspension. I will ask for that motion.
So moved.
Second,
I'm sorry, can you read that again?
It's a 1-day suspension for a third group 1, a 2-day suspension for a fourth group 1, and then a 2-day suspension for a group 3 violation.
Thank you. Commissioner Barrow,
Yes.
Commissioner Mears,
Yes.
Commissioner Banks.
yes.
And clarification, that's 1 employee.
Correct.
Thank you.
Right. Now we'll move on. Well, I guess we technically have to, we can go into executive
Thank you
session.
very much, guys.
You're
Thank you,
welcome.
ladies.
Can you get me dates?
Yeah, we need dates.
Thank you.
All right.
Bye-bye.
At this time, I asked that we go into executive session to discuss employment of a public employee at our wastewater.
We have to wait for 2 minutes.
Yeah, I think we're okay because we can go into exec, because we'll come out formal action after
All right.
30.
So moved.
Second,
Commissioner Barrow,
Yes.
Commissioner Mears.
Yes.
Commissioner Banks.
yes.
Okay, it is 11:11 and our HR director did a phenomenal job of presenting to us information that we needed to review. She will go back and discuss that with our wastewater director, Amanda Miller, and they will come back with a formal recommendation sometime here in the near future. Any other business out there? Seeing none, we will adjourn at 11:12.
Thank you both for the extra.
Nice job,
time
Kelly.
In the preliminary discussions.